Alors, mesdames, messieurs, bon après-midi. Comme la conférence de cet après-midi sera en anglais, I will switch to English right now, if for no other reason than for our lecture. Good afternoon. It's my pleasure to welcome all of you to this fourth conference in our lecture series of the Evenings of Justice that is taking place at the University of Montreal's Faculty of Law, but that is organized by the Centre de Recherche en Droit Public. My name is Nicolas Vermez. I am the director of the Centre de Recherche en Droit Public, the CRDP, and it is my great pleasure to welcome all of you tonight to this virtual presentation. Our speaker tonight is a friend of the CRDP and a personal friend of mine, so it is my great joy to welcome him tonight for this lecture. Fred Lederer. Fred is the Chancellor Professor of Law and Director of the Center for Legal and Court Technology, or the CLCT, at William and Mary Law School. For those of you who are a little older, that used to be Courtroom 21, but changed its name a few years ago. He has, as you may have guessed, a very impressive CV. I'll just point to a few elements. The fact that he served as an active duty judge's advocate general for the United States Army. Served as a prosecutor, defense counsel, and a trial judge. He was one of the founders of the American Bar Association prize-winning William and Mary Legal Skills program. He teaches, as you may guess, technology-augmented trial practice using the sophisticated equipment in the McLaughlin courtroom, which you can see a picture of behind him. The McLaughlin courtroom is the most technologically advanced courtroom in the United States. One of the most advanced in the world. We have a friendly rivalry to know if it is more advanced than the Cyber Justice Laboratory courtroom here at the University of Montreal. And I will let all of you decide at the end of this lecture if that is the case. But all joking aside, it's always a great joy and pleasure, as I mentioned, to share the podium with Fred. And without any further ado, I will cede the floor and the microphone to him. So thank you, Fred, for accepting to speak with us, and please start your presentation.
And thank you, oh dear and most respected colleague. So, ladies and gentlemen, as you've heard, I'm Fred Lederer from William and Mary Law School in the United States. We would point out that we are the oldest law school in the US, even if you've heard something about this upstart called Harvard Law. We are also the second oldest university. Now, as to the respect, I will simply observe, along with the Cyber Justice Laboratory, I think it's fair to say our two courtrooms are generally considered the world's leading experts in the field. And it is always an honor to deal with our Canadian and friends. So I am here to talk about topic, and you should be able to see the screen with it, technology-augmented courtrooms. And I've added to that an introduction with a human rights perspective, because it is all too easy to be lost in the details of the technology, the joys of success, the rather painful experiences of limited failure, never anything beyond that, of course, and yet to sometimes forget that there are goals behind what we're doing. So as you've heard, I have the pleasure to be part of the Center for Legal and Court Technology, better known, as you've heard, around the world, as from our original name, the Courtroom 21 project, then the Courtroom of the 21st Century today. Our mission is on the screen: to improve the administration of justice, appropriate technology, and I've decided appropriate. Yesterday afternoon, I was teaching, and I was attempting to have one of our students show a PowerPoint presentation. And let's just say the very old computer in the classroom had decided to show its age. At that particular moment, I think there were a fair number of people in the room who, given access to a sledgehammer, would have used it instantaneously to remove the technology problem and the technology with it. In the reality of the world that so many of us work and live in, it's not enough to have technology. It's got to be useful technology, reliable technology, appropriate technology. And that's one of the themes here. But a little bit of other background before we plunge into the subject. Our original focus, as the slide indicates, was in the area of dispute resolution. It was a question of how could you use technology to make dispute resolution better? Well, what's better? We have usually thought that there are three possibilities. First and foremost, making it more accurate. Second, making it more efficient, which is not always the same as being faster, but often much the same. And if at all possible, cheaper. And over the years, at least our conclusion is that you're rather lucky to get 2 out of the 3, and it's rather hard to get 3 out of the 3. And I would leave that to my distinguished colleague from Montreal to pass on their experience in Montreal. I should add, by the way, that for those of you who are French speakers, I must apologize. My French is, let's just say, worthy of a diplomatic incident. So I apologize that I am inflicting English on you at this point. It is, however, in everyone's best interest. Not too many years ago, about 8, we expanded into the interrelationship of law and technologies such as artificial intelligence and the rest. And we are cooperating with our colleagues in Montreal, particularly on that. So that brings me to the human rights perspective. And from a human rights perspective, the question becomes, what is it that our goal is in disputes and dispute resolution? And as I suggest to you, I think it's fair, accurate, and impartial adjudication. Now, I understand I'm at a grave disadvantage to discuss Canadian law, particularly the Canadian Charter of Rights and Freedoms. But I thought this might be somewhat more appropriate than relying on the US Constitution. So at least insofar as criminal matters are concerned, the Charter expresses the key requirement of a fair and public hearing. The key word, I think we will all agree, is fair. The public is also a part of this. And my focus today, in part, is to question whether the various components that make up a technology-augmented courtroom, and to some degree the court itself, whether it fits the requirement for fairness. So if we were to go ahead and discuss what is courtroom technology, we have a laundry list, as we say in my country. First, we deal with the court itself. That's not a topic that I'm going to deal with today, although you may want to discuss it. I might add, in terms of administration, I would suggest that we take up questions largely at the end of the presentation. If you have anything particularly pressing, feel free to just talk. Make sure you don't mute yourself in the process. And I will apologize, I'm not going to be able to look at any chat function while I'm in the process of this. Now, increasingly, as all of you are aware, modern courts and courthouses are basically data centers. Information is brought into the court from the outside electronically. It's stored in the court or perhaps in the cloud. It's used by the participants, court administrators, lawyers, and judges. We have case management systems. And in a better world than we often have, we might actually have this data being interchangeable, not only within the same courthouse as we hope we have, but potentially in other ways as well. But I'm not going to address that directly, except to note that that is part of what we're talking about. Courtrooms are not locations that are isolated from the rest of the legal system. So in the courtroom itself, I divide, as you have seen on your slide. We have, first and foremost, infrastructure. Now, if you were all a group of technologists, and perhaps you are, then I should be talking about infrastructure. But I'm assuming that most of you are not. So I'm only going to mention this briefly. Now, the problem with mentioning it briefly is its importance. On Monday, this past week, we were visited by the chair of the Technology Committee for the Virginia Judiciary. And he wanted to know what the first and most important thing that should be done if a court gets funds. And the short answer is you create the technical infrastructure that will allow you later, when you have more money, if necessary, to do what the court needs to do in the courtroom. Even today, that largely means, even in the age of Wi-Fi, that we are talking about cabling, particularly fiber cabling, fiber optic cabling. I'll talk a bit more about that in an appropriate moment. Then a topic I will not address, and that's security. Courthouse security is important. All too often, when it's inadequate, very bad things happen. We don't deal much with it because our facility is in a law school, just as our Canadian counterpart is as well. And it tends to be rather difficult, and if you'll forgive the term, thankless, to try to ensure that you have a full-scale security system when a large number of late-coming law students need to get into the room. It tends not to work well. But then, when the home computer revolution began, or the personal computer revolution began, we used to talk about killer applications and such. Well, the application, at least from a US perspective, would be for courtrooms evidence presentation. And by that, I actually mean more than evidence, and we'll talk more about this shortly. We're talking about the visual presentation of information in many different ways. And that is the original, arguably key function of a technology-augmented courtroom. And then we have the court record issue. Certainly in the US, a court of what we call general jurisdiction is required to make a word-for-word or verbatim record of everything that is said in the resolution proceeding. Let's just say in the hearing, which is more accurate. In the United States, and that's a question I'm going to ask all of you to consider, with some very rare exceptions, this is all required to be ultimately in the form of a text transcript. And one wonders if that, in fact, is quote unquote fair in the modern age of technology. So we'll talk about court record. And then, for want of a better way of putting it, we're going to talk about video communications, which is what we're doing right now. Originally, that was remote testimony, although it expanded rapidly when COVID arrived. And I'll be talking about what we learned before COVID and during, and I don't think, unfortunately, we can say it's after COVID as yet. We still have those problems, but things are certainly better. And I will end with a discussion of assistive technology to help those people who, at least in our country, are often said, although we might argue about that, to have disabilities. Many of them don't think those are disabilities. So that's my framework, if you will, for this. So I thought we might start with a couple of pictures for orientation as far as that's concerned. This is our courtroom. This is the McLaughlin courtroom. And this picture was taken a fair number of years before COVID. And what you're seeing is a perfectly normal use of the courtroom. We call this a laboratory trial. A laboratory trial was designed to take place every year. COVID certainly interfered with that. And we would try a case. Not a real one, but often one that was based on it. We would bring in a sitting judge. In this case, the judge was a federal district judge who was the director of what we call the Federal Judicial Center, the research and education arm of the federal courts. And we would have a community jury, and we do our best to try this in an afternoon. And our goal was to try to determine what happened when real human beings, particularly real legal professionals, had to cope with real technology in a legal setting. And I am honored to say that we have been honored by our colleagues in Montreal and had their assistance any number of times. And I'm resisting the urge to show many pictures of Nikolai. So in this case, you see a remote witness testifying while counsel is presenting evidence electronically. The jurors not only see the remote witness, but they are looking at the documents about which the witness is testifying. And at that time period, we tried to have one display for each individual jurors. Then, before the judge's bench, there is a court reporter who was a real-time stenographic reporter, taking down every word that was said, and it went immediately to judge and counsel, and if we wanted to, anywhere else in the world. And to our right, you see what we call a courtroom technologist, the person who will run the courtroom under supervision. Now, while this is a quite old picture, and much of the technology has now changed, it's still pretty accurate for what a technology-augmented courtroom can look like, certainly from the US perspective. But of course, this is not the only way of doing things. This is Vancouver, British Columbia. It's quite old. I don't have a current picture. This is 2009, and this was a picture of what at the time was one of the highest tech courtrooms in the world. Of course, surpassed by Montreal, but that goes without saying and such. And this, of course, is Montreal, with my distinguished colleague there a year or two ago. Is that fair? And such. And while this is not a current picture, many of you are, I hope, I'm sure, familiar with what the facility currently looks like. Now, all of these, at least the three, are technology-augmented courtrooms. They all look different. There is no particular look that is standard or critical, but it is true that most technology-augmented courtrooms are traditional courtrooms where technology has been added customarily after the fact. If we're very lucky, we're talking about a new courthouse project or a massive renovation, and then you get to do it right. But most courtrooms, including the one you see behind me, are what I call a retrofit, meaning you do the best you can in the space that you've got, and you always then get compromises. I have been speaking of courts consistently. In the United States, this is incorrect. I'm fairly certain, from what I know, it's incorrect in Canada as well. And I do cordially invite my learned colleague to make comments if he feels at all comfortable to add from the Canadian perspective in particular. We have a fairly large number of federal agencies. Most of our states have administrative agencies, as do your provinces. And one of the evolving elements of our federal agency adjudicatory hearings is that they are going high technology. This picture is a number of years before COVID began. We have what's called the Social Security Administration. Most of you have probably heard of it in one form or the other, having to do with retirement pensions, so to speak. But one of their biggest functions is to award what amounts to pensions to individuals who cannot work any longer because of medical concerns or injury. Now, that means that an individual who has a proper work history files a claim asking for a pension, and if not granted in the first round, eventually goes to a hearing with a federal administrative law judge in a hearing room. And I might add, there are usually two experts. One is a vocational expert. The other is a medical expert to ask, what job, if any, is this individual still capable of handling? You're looking at a picture that we took. We spent 5 years helping to modernize their hearing rooms. And please note, in an average non-COVID year, and this number is not a mistake, our Social Security Administration holds 700,000 actual hearings. When COVID hit, they went remote. The number they gave me was 100,000 remote hearings. So when we talk about technology-augmented courtrooms, we're also including hearing rooms, and at least insofar as the US is concerned, we're talking about an immense number of technology-augmented dispute resolution proceedings. Does that mean that all our local courts are high-tech? Certainly not. Are they heading in that direction? Yes, but sometimes slowly. This is the bench for a Social Security administrative law judge. You see that it's fully computerized. There are 2 separate monitors. I might add that the Social Security judges are unionized, by the way. And apparently, as I recall, they fought over the issue of needing 2 monitors. One to look at the case evidence, one to look at things like case management. And you see the classic CLCT cutout, the curve. If you're a judge, or you're a lawyer for that matter, and you need to be able to see displays, you don't really need to be stopped by the table you're sitting at. This way you can get up closer if you need to. Well, that brings us to what is it that we are seeing, and to an increasing level is arguably compelling us to use technology in courtrooms. And one answer to that is, as my slide suggests, is the ever-increasing need to present evidence from smartphones and other forms of visual information. It's hard to get accurate data. The judge that we had that visited us on Monday normally handles family matters, juvenile and domestic relations, and spoke about the immense amount of evidence that comes into that type of courtroom, which comes from police body cameras, from cameras in police sedans, individuals' phones. We have text messages, we have emails and evidence, and we have social media video evidence. It never, ever stops. This was the last lab trial before COVID hit us. We did this for the United States Navy, and we'll talk more about this later, because the key concern there was the potential use of artificial intelligence to create an automated speech-to-text record. So in our plot line, so to speak, we had 2 members of the Navy who went out to lunch together, had a fight, and one assaulted the other. Well, what would happen in the normal real world if you or I were seated there and suddenly there was an altercation? I would suspect strongly that, at least in the US, and I don't know that Canada is very much different, that a fair number of people would immediately grab their phones to take pictures and to record what's happening. Now, please understand, by United States stereotypes, all Canadians are incredibly courteous and polite. So it is possible that if that were true, that you would have less of this and perhaps none at all. I suspect that's not quite right and such. So someone would pull out the phone and would record what you're seeing on our jury monitors as we played at the actual trial. How do you do that? Now, many of you have immediate answers. The problem that we often have is our courtrooms are not necessarily built for this. So if we go back, for instance, to the juvenile court that I mentioned, people walk in with their phones. By the way, a small side comment. I'm in Williamsburg, Virginia, well known to many Canadians, but it was advertised heavily in Canada. please come down and see Colonial Williamsburg, particularly our courthouse from 1770 or so. But it happens, when you think about this, that evidence is fairly critical, regardless of the time period. And here, how would we play this video? Well, in Virginia, because of our, shall we say, traditional roots, it turns out a fair number of courts don't allow cell phones even into the building. Technology-augmented courtrooms get you absolutely nowhere if you can't bring the technology-based evidence into the building. And that is sometimes a condition prerequisite, as we say. Hard to have fairness if you can't get evidence. So when we design courtrooms, and we do design them around the world, you have to install the ability for an individual to walk in with a cell phone and to go ahead and show the audio, video, or still image content to the judge and to anyone else it's appropriate to, such as a witness and so on, or on large screens for public viewing. After all, the Canadian Charter talks about public trials and such. So how do we get the stuff from the phone onto the monitors like this? And that's a technical issue. You know, there's a tremendous amount known about how to market to people in both our countries. There's been relatively small amounts of research done directly on what happens in courtrooms in evidence presentation. I might add with envy that the Canadian national government, and I suspect the provinces as well, seem to be far better at supporting fundamental research in this field than is often the case in the United States. And by the way, if any of you watching are part of those organizations, bless you and thank you and such. But what we do understand from the marketing work and what we think we have experienced here in our own courtrooms is that when we present information visually, things work out better. Now, it's not just marketing. There are studies, most of you know, and some of you are academics, there's been a fair amount of work done on how people learn in schools. So there are people who are visual learners. There are people who are auditory learners. There are people who do well with both. By the way, law students tend to be very big on audio, as it is. We're really good, by the way, on reading stuff. So as best we know, visual presentation improves first, understanding of the information presented at trial. Second, we remember it better. And from a trial lawyer's perspective, and that's all the trial lawyer's perspective, you do a much better persuading people when they are able to see as well as hear. Well, that raises any number of questions. We're going to present information visually. The first question is, what the heck does that mean? Well, using the standard trial format that both countries share, often we will make legal arguments. Traditionally, we do this speaking, handing up paper. In the more modern world, electronically sending information. In our courtrooms, what you do is you do it by just showing it on, you call it up on your computer, and it is displayed throughout the courtroom as necessary. If we're doing a trial, we usually start, to oversimplify, with an opening statement. We teach our students, at least at William & Mary, how to make high technology opening statements. Sometimes that's as little as a photograph or two that anchor the fact finder, judge or jury or both in what the case is about. Sometimes it's a PowerPoint. Now, for those of you who have had more than enough experience with PowerPoint and have an interest in my word appropriate and wonder if we can't ban them for life, I would note that our course in technology-augmented trial advocacy requires what we call a PowerPoint workshop. Our students are required to do a 7-minute approximate presentation. It can be on anything, including their pets, their vacations, and so on, accompanied by a PowerPoint show. And in the process, they get to see, when we have a really good year, every conceivable way to do it wrong, which then does a great job of helping them do it right and such. So then we have presentation of evidence, we have closing argument, and in our courts, where we are giving instructions to the jury, we can in fact also show the instructions, scroll the instructions in PowerPoint form or otherwise for our jurors. So what technology do we use? Well, first we use document cameras. In the US, this was the first and most basic form of visual presentation information. They were, I understand, originally designed for television station use. You put anything underneath it, and the gadget itself is basically a vertically mounted television camera. And then it displays wherever it's supposed to display in the courtroom. Here, I'm showing a circuit board here, and we're using a document camera from the Wolf Vision company from Austria. There are numerous companies that manufacture all this hardware. And in this particular case, we're just going to call it a document camera. In the US, they sometimes have individual company names they will use. This is something that our experience has proven is certainly possible, and we don't think you want to do. This is trying an entire case from a smartphone. And here you see counsel, student counsel, presenting her visual evidence entirely by phone. Can you do it? I've already suggested so. Some of you undoubtedly have. Doesn't work as well as using a larger device that is much easier to use here. And that's how we most normally use it. Counsel normally prefer laptop computers and similar devices. Many different types of devices. And I thought it might be useful to show this to you. This is a program running on an iPad. The program is TrialPad. It's running a specialized evidence presentation program. Now, the one that runs on notebook computers, there are two principal ones in the United States, and I'm not sure if they managed to penetrate Canada. One is called Trial Director, now called Trial Director 360, which was purchased by the iPro company. And the other that actually had a common origin in some respects is called Sanction, and it was purchased by LexisNexis. This was a similar type program designed for iPads and similar devices. On the left is the list of the exhibits. Now, we could say of the images, and that would be correct, but since this is being done for a trial, they are the exhibits that counsel may want to display throughout the augmented courtroom. So on the left, the person has used a finger to touch the Matthews contract. On the right is the Matthews contract. This case is one that we use for teaching our law students, and it all involves an individual went for a riding lesson and fell off the horse. A bit more to it than that, but that's pretty much how it works. And this is the original legal agreement, which is critical to the case from both sides. How much technical knowledge does it take to use this? Probably about 1 minute, as far as that's concerned. Now, getting it into the system is a little bit different. And another type of evidence, for those of you who haven't done this at great length at this point, this is pre-recorded audio video. In this particular case, it's a deposition. and our experience, and that of many lawyers, I think, in both countries, is the ability to present previously recorded audio video is sometimes the proverbial game changer. Now, of course, you have to do that work in advance of trial, but you also have to have the ability to do this meaningfully in courtroom. Now, one of the topics that will come up on a tangential form is our country in particular tends to be very much jury-centric. The total number of jury trials that we have is far smaller than our population imagines. You too have jury trials. And although our law is different, it doesn't do you a whole lot of good to present evidence unless the jury can see it. Well, that's fine. They see it in the courtroom. Are you going to allow them to look at it during jury deliberations? If so, where are they going to watch it from? The classic solution is to bring them back into the courtroom. Increasingly, however, although not frequently yet, the courtrooms that we see that are high-tech are designed so during deliberations, the jurors are able to replay selected pieces of audio, video, or image evidence. And then there's the question of how far do we go when we talk about the whole question of visual evidence. Years ago, we did this. It's unclear. This may well be the world's first use of virtual reality evidence. And as we get there, we'll talk about 3D evidence in particular. So here we have a case in which there was, think of it as medical malpractice. And what happened was, the question was, what was the cause of the medical injury? And the plaintiff had a nurse who was part of the team that was responsible for the operation and the surgery, and she was prepared to testify as to what she had observed. The defense said that she couldn't humanly have observed that. So here we put what happened in the operating room, which was specifically the dimensions of the operating room, the table, everything else, into virtual reality. The gentleman with the device on his head was a scientist from the University of California at Santa Barbara. And when we actually did this, that's a rather well-known federal district judge on the bench, by the way, the jury was able to see what the nurse could see because she put on the headset, and lo and behold, it turned out that the nurse could not see the doctor's hands, wrists, or arms and was entirely impeached and discredited. Now, whether this was the first or not, we don't know. There is a claim there was another one, perhaps a little bit early. There hasn't been very much since that time. There have been, by the way, experiments in the metaverse, and we're heading for that one more time. And whether this is a better solution than a straightforward online dispute resolution system, which our colleague, Professor Vermeijs, is a world expert on, I would leave to him and to others. It certainly looks entertaining if we're going to have avatars running around a almost cartoonish recreation, but that's not how this worked. So where do we display all this information? Well, we do so in courtroom displays, and that has raised any number of questions over the years, particularly on issues of fairness. Originally, the early courtrooms tended to have very large displays, projection units, 1 or 2 in a courtroom. The great advantage to that was everyone sitting in the back of the courtroom could see the evidence, for instance. And indeed, we had quotes from distinguished judges that it vastly improved the media's ability to go ahead and understand what was happening at trial and cover that. We're talking about a human rights perspective. Don't we want the public to know what's going on in our proceedings? And we hope to understand and appreciate it and to be able to criticize it if we're not doing it well. Then we went to large monitors, large televisions, and we tend today to have individual monitors, multiple people per display, possibly, as I'll show you in a minute, tablets. And then there's always the question. It's one thing to design the courtroom for the judge, the counsel, other court officers, and if you have a jury trial, for jurors, but are we going to go ahead and permit the individuals in what we call the gallery to see this? For years, we asked visiting judges, and just like our colleagues in Montreal have had innumerable visitors from around the world, we've had an awful lot of judges. So focusing on judges from the US and Canada, we would ask them, have you ever had the experience of having a person in the gallery, in the audience, perhaps stand up during the trial of the case and say, Judge, when do I get a chance to see the exhibits and the evidence? After all, it's a public trial. And actually, in all the years, I actually had 2 judges who actually said that. And I asked them, what did you do? Judge 1 said, I told them to shut up and sit down, but I was polite about it. Judge 2 said, see me during one of the breaks, the recesses, and we'll show you the stuff. Well, one of the things that technology-augmented courtrooms do, and hearing rooms, is they change social expectations. We'll get to that in particular when we get to the post-COVID scenario. So every time we design a courtroom, the question is, how will the gallery see? If you look at the Cyber Justice Lab, which has the largest screens that I know of anywhere, they've answered that question quite affirmatively and quite well. What about the tablet bit? Well, one of the problems with displays is people have differing abilities to see. So is there a way in which we can help? If we use tablets, then the person can take the tablet and hold it directly in front of your eyes if need be. Unfortunately, tablets are portable. And by accident or by intent, they might decide to take a trip away from the courtroom. So that's been one of the small problems that's been difficult for some courts. And here you see a somewhat larger screen. So there are courts that have experimented with tablets. And while I haven't gone in that direction here in this presentation, we have experimented and had wanted to experiment more before COVID stopped us, with what we like to call a courtroom in a box. Basically, you ship tablets in along with the basic hardware to use Wi-Fi, and then counsel use a computer, and we display what we want to tablets just like this. By the way, it does work. It's fairly inexpensive. It doesn't have all the capabilities that a full-scale high-tech courtroom have, but it works surprisingly well. And that then brings us to remote appearances. The use of video and audio to allow people in other locations to appear in a hearing room or a courtroom has always been of potential obvious value. Now, whether it's lawful, whether it complies with our Constitution or your charter, those are difficult questions sometimes. We did a great deal of work before COVID. So this was a very old case. This is, in fact, what our courtroom used to look like when we all started here. And you're looking at a witness appearing live from London. Now, our experiments, and there were 2 separate major experiments, separated by 1 year, run by a William & Mary professor of law and psychology, indicated that if we had remote witnesses, life-size, behind our witness stand, we got the same results we would have if that individual were physically in the courtroom. And for those who have an interest, I can certainly explain how we did that work. Now, by the way, that doesn't mean that rolling a TV or something that's sent in the courtroom is wrong. We never got a chance to test that. We did test this, and this did work quite successfully. This was the straightforward, simplistic. This was taken a couple of years before COVID. We have, as you may know, a rather large number. Well, we have a huge number of people who have entered the United States without lawful permission. And we have immigration courts. And they've been trying people for unlawful entry for years. And this is in a detention facility south of Richmond, Virginia. And what you're looking at is a small cubicle, and you're looking at a rectangular display divided into 4 portions. We call this a quad split. And there's a camera on there. And 5 minutes after this picture was taken, because I took it, the individual who was in detention pending deportation, who was appealing claiming he had a right to remain in the US, was looking at the judge in Arlington, Virginia, and other individuals. This is what he saw, including on the right, the full screen vision. Well, going back just a moment, there's an interesting fact about this. He had a lawyer. Unfortunately, I never asked whether she was pro bono or charging. Most of our people pending deportation can't afford to retain counsel. His counsel drove 2 hours to get to this facility so she could be there in person with him. Could she have appeared remotely? Under today's technology, easily, then possibly. It could have been done, just not easily. Right after this gentleman walked out, she and her client walked in, sat down. 5 minutes later, the remote immigration judge announced, "I'm sorry, this case is clearly not ready for hearing. We will continue it to another time." She had to go back and drive 2 hours back with nothing having been accomplished except a short meeting with her client. How do we want our legal systems to work? How do we provide access to counsel? How do we give meaningful access to justice? That's a fundamental human right in both our countries. And then there was this, and we were so proud of ourselves. This was a lab trial, an experimental case, in which we had a woman in her 80s, and we assumed, for purposes of our experiment, that when summoned for jury duty, she wanted to serve, but she had physical conditions that meant that she couldn't come to the courtroom. So we gave her the ability to participate remotely. And of course, today this seems so matter of fact. Then it wasn't easy at all. We put a court officer in her living room with her, so everything would be done properly. She had full control over the camera that is above the screen that you see her on, and she could therefore look anywhere in the courtroom. When it was time for jury deliberations, we transferred her electronically into the jury deliberation room. We had no idea that COVID was coming. This is, as far as we know, the first ever remote juror in either of our countries. And it opened the door to the debate in our country about remote jury trials. You'll see this again before we all finish. This was recent experiments just before COVID with remote foreign language interpretation, in this case, Mandarin Chinese. In our legal system in the US, there is no requirement that an interpreter have to be physically present in the courtroom or that we need even see that person. However, besides law and culture, there's also comfort. And here, what we discovered is, not that this was a broad enough data sample, that jury and judge were much more comfortable when we could see the remote interpreter. This is a remote appeal. You are looking at the United States Court of Appeals for the Sixth Circuit, a major federal appellate court. And again, this is all pre-COVID. Each of those judges was appearing remotely from a notebook computer, a laptop, from an entirely different courthouse. Again, before COVID, this was controversial This was concerning. This was exciting. Did we make a mistake? Yes. The judge in the far left should have been in the center. She was the chief judge. P.S. We heard about it. And the point here is, not only could we do this for appellate purposes, as we have now done repeatedly in both countries at various times, but particularly culture is important. If you're using technology to accomplish a goal and it does not match culture, even though it matches the legal requirements, it tends not to be acceptable or work well. And we did a fair amount of experiments with pretrial motion practice. So we have a company in California called Court Call. I believe they've expanded into into Canada. And they pioneered originally doing lawyer motion practice by telephone. And as you see some of the data, they claimed at the time I interviewed them, 5 million remote appearances, saving hundreds of millions of dollars. And then they expanded into video. What was particularly brilliant about Court Call, which is one of our many, what we call CLCT companies, is that they got not only clearance from the California courts to do this and to have them partner. When they charged fees to the lawyers, they split the fees with the California court system, which meant the court system was surprisingly, wasn't cooperative as far as that's concerned. And then, as most of you are probably familiar, British Columbia was world famous for the degree to which its courts would provide for remote judges when you needed a judge and there wasn't one in your local court. It did a superb job. As far as I know, it's still doing it. Because in those days, no Zoom, no Teams, no WebEx, I could go on. We did have some data, in case you were interested, talking about fair trials, access to justice. In 2016, there was a survey and found that 46% of small, rural, tribal, and border courts in the US used video technology for hearings. It was the right way of doing it. In 2005, we experimented with an international case, an international parental abduction case. So here you see counsel wearing headphones. We assumed that we had a couple, American parent, a Mexican parent, and the Mexican parent had taken a daughter to Mexico when the marriage dissolved. And each parent wanted full custody. And there's, many of you will know, there's something called the Hague Convention that should have resolved the case, but we had an exception to the Hague Convention. So here we asked, was it possible for two courts in two different countries and two different legal systems to cooperate together, could make an agreement on how this would work, and then hold a trial in common? So each court is sovereign and independent. Each court makes its own decision, but here they have agreed to take evidence from the other court, back and forth. So our counsel's wearing headphones because when he asks a question in English, it's being translated into Spanish. When the remote witness, or our witnesses, because our witnesses are bilingual, answered an English question from counsel in Spanish, we handled the interpretation in both areas. And of course, interpretation is a critical area. I'll touch on it. We have time at the end. And it's an area where Canada knows a whole lot more than most folks in the US. This was, by the way, the judge in Mexico. We worked with the highest technology court in Mexico. And this was the multi-image video from Mexico that we were seeing in our courtroom. As far as we know, this hasn't really been done since then. We did have further experiments in mind. We did do an experiment with our learned colleagues in Montreal involving an investigative commission. So then COVID arrives. And in COVID, we have done all over the world what we are doing right now. We are holding trials, having hearings, having legal matters resolved remotely. I'm sure there were thousands that beat us to it, maybe not, but this was one of the first straightforward Zoom-based bench trials. This was students, not real. And of course, it's not hard. Now, if there's interest, I can tell you a fair amount about how US courts actually did this. I can tell you about how our federal administrative adjudicatory agencies did it. But I can tell you the most important thing right now, very simply. Pretty much every judge that we interviewed, and we did a major research project for the federal administrative agencies, told us the same thing. Despite aggravation, particularly glitches, problems due to limited bandwidth, and so on, it all worked. It worked well. And in most cases, we should do this after COVID, maybe not all the time, but at appropriate times. And if you're curious, why did it work well? Because most of our courts and agencies arranged so that they would have pre-hearing meetings by video with counsel and the parties to be sure that their equipment worked, they knew how to do it and what the protocols were for that particular hearing or trial, which meant that we had extraordinary personnel demands on the courts and the agencies involved. That was the price to make it all work. So that raises the following human rights issues, among others. What's the difference, if any, between remote participation and in-person testimony? As I ask in my slide, do judges and jurors react differently to remote testimony? I told you of the experiments we did in our courtroom. The experiment said if you did it in one particular fashion anyway, we don't get differences. Now, by the way, there's a world, forgive my word, world of difference between what people think, how they think they behave, and the reality of their behavior. The experiments indicated that individuals often thought they reacted differently, but in fact, they had no difference whatsoever. People are often not very good at realizing how they actually make decisions and so on. Now, in both countries, and if I'm making a mistake, I ask my colleague, Professor Vermeijs, to interrupt. Our proceedings are often oriented around what in the US we call demeanor evidence. That is the ability of a fact finder, usually a judge or a jury, to determine whether a testifying witness is telling the truth or not. This is fundamental to the US legal system. As far as I know, it's been fundamental to the English, the UK, and the Canadian system. This raises important human rights questions for remote testimony, particularly if it is prosecution testimony in criminal cases, which in the US raises constitutional issues and probably questions under the Charter. The scientific evidence indicates that judges and jurors, at least in the US, can't actually tell truth-telling or not as a result here. If it turns out that they can, then the question is, can they do it by remote video? And the short answer to that has been, before COVID, almost every trial judge who ever visited our courtroom, and that's a great number, always expressed doubt that they could tell whether the remote witness was telling the truth or not, because they weren't sure they could determine the demeanor evidence adequately. What happened during COVID? I haven't met a single judge who expressed concern. And trust me, that's a lot of judges. Turned out that COVID led people to believe that if they can do it at all, they can do it as well remotely. I believe this is a legal fiction, and it is a primary problem for remote testimony in criminal cases. What about remote juries? I'm only going to speak about the US. The history of juries, as you know, goes back to the idea that we'd have a jury, a group of people forced to be together, and to make a decision, basically under pressure. And there's historical evidence that if a jury didn't finish in time and the judge had to go to another community riding circuit, we'd pack the jurors into a wagon and take them with the judge. We've had a number of remote jury trials in the United States. As far as I know, they've all been done with consent of the parties. Is a remote jury the same as a physically present jury stuck in a room with each other? I don't think it's the same. Now, in the US, with a remote jury, we could have two different variations. Variation number one is all the jurors are somewhere else in one place. I was asked about that years ago in the UK for a terrorist case. Well, arguably, that is the same type of deliberation problem. Maybe that's a jury, and then we have to worry about the demeanor evidence issue. But what if we have everyone appearing from their kitchens or their living rooms or their offices or whatever, setting aside the question of whether they're distracted and the rest? Is that the same type of deliberation and decision-making? We have a movie, a fair number of you may have seen, A Few Good Men. Today, we probably have a few good people. I would say not. And I think that's a really issue. On the other hand, if we're focused on fairness, then we have questions of affordability and convenience. To what extent do we want to broaden the pool of jurors? To what extent do we want to make this easier on people? Does that overcome issues? Please note, I haven't suggested that remote juries would be a bad thing. I suspect in many ways they'd be far better than what we're traditionally doing. I'm just suggesting that from a legal perspective, they're not the same. And therefore, from a US perspective, probably violates our Bill of Rights. I wouldn't dream of predicting what the law would be in Montreal or in Canada as a whole. So I now show you the most recent development. You're looking at my courtroom, the McLaughlin courtroom, approximately at this point 2 weeks ago. And you are looking at the world's first use of life-size, three-dimensional, holographic remote testimony. This is a large white device, looks like an old-fashioned phone booth, not in the UK, of course. And what you're seeing is a remote witness. And you're not close enough to really see how 3D that really is, but it is very, very realistic. And in this case, she's holding a brick, a piece of evidence. And if you were there, you would be able to see the jagged edges of the brick. This is, as far as we know, the world's first use of this for legal purposes. And we're the first courtroom in the world to be able to do that. I do hope at some point we'll be able to have the same capability in Montreal. So how does this change the definition of a technology-augmented courtroom? How does this change the question of whether this is the same as being there, or if not, is good enough? In our country, it is because of what we call the Confrontation Clause of the Sixth Amendment. It is unconstitutional for a remote prosecution witness to testify in a criminal case. There is one very limited exception dealing with child sexual assault cases where the witness is the child. Canada has the same exception, but perhaps not the same limits. So that is developing. And then in the UK, and Professor Vermeijs would do a much better job of both explaining that and what's going on in Canada. We have online dispute resolution, and that will be increasing. Is that a technology-augmented courtroom? Not by our definition. Is that the future? For some cases, oh, absolutely yes. So, though our time is running out, and I want to allow time for questions, what about the court record? The ability to know what actually happened for appellate purposes or for trial practice use, where the lawyers are, for instance, able to say, isn't it true that in Monday's session you said as follows, and I quote from the electronic transcript. Right now, we have stenographic reporting, an individual these days using a machine, printing out code using a code stenotype. We have voice writing that traditionally used to be speaking into a mask and then recording it and then transcribing it, now is speaking into a computer that is trained to the voice of the individual speaker, and digital recording, whether audio or video, and then AI. We'll get to that. This is a stenographic court reporter doing remote reporting from our courtroom. Very, very old. This is about 18 months ago. We have a company called Revolutionary Text that before COVID had helped pioneer the idea of having a remote court reporter who by video conferencing sees and hears everything. This is a deposition, and sends it out in real time instantaneously. So if you wanted a court reporter, a human court reporter, we can do that. This is voice writing. This gentleman is a voice writer. He is one of the best in the United States, probably the best US or Canada. And he is producing a real-time and immediately available text transcript that is amazingly accurate, in this particular case, for counsel and the judge. This is the world's first known virtual reality court record we did in our courtroom. I think it was about 2 years before COVID hit us. And if you wanted to, you could put a headset on and you'd be right in the middle of the courtroom and the trial. You could look around and you would see everything, you'd hear everything. Is that the type of court record that we ought to have? It would certainly be more inclusive. And we don't have to worry about whether the court reporter made an error. This is, if not the first, one of the world's first artificial intelligence-based automated speech-to-text AI-based systems. The system knows who's talking, and it gives us text. My understanding from the company that does this, and this is the 2019 experimental trial, it's better now. We've had a more recent experiment with it. This is from the company FTR, one of our companies with whom we have a great relationship. And they claim about 94% accuracy. Well, we're not sure that's good enough, although human court reporters make mistakes too. But this accompanies the digital audio and video. So if there's any doubt, you just click and you hear the original recorded audio and video, which should give you 100% accuracy. What type of record do we want? And by the way, to what degree would an appellate court, especially for demeanor evidence purposes, be able to evaluate how a witness actually looked? Our courts don't do that now because we don't have that capability. P.S. in the US, we've gone to great lengths to be sure we don't have that capability. Kentucky was the one state that throughout the US for many years permitted recorded audio and video and required or permitted that to be submitted at trial. This, by the way, is a combined multimedia court record. That's everything together, including actually seeing the evidence as it's done. This is our CLCT composite record. And then toward the end, we deal with assistive technology. The Canadian Charter is specific on this, whereas the US Constitution is not, but we all have statutes dealing with it. How do we accommodate, if that word is appropriate, an individual who has inability to see or see entirely, hear, speak, move, or many other possibilities. And a key question, I once asked our local court, what would you do if someone who is blind came into the courthouse and wanted to look at a court record? They said, well, we'd just send an employee out to read it to that person. If you ask most people without sight, they would say that's unacceptable. I should be able to read it myself with my own equipment. This is our witness stand. It's a wheelchair lift. You see it from the front. In 2006, years ago, we did a major experiment with assistive technology. Here is counsel in a wheelchair in a specially designed location for counsel to wheel in and present evidence electronically. You see there's a voice writer there. Counsel here has a very real condition called Gulf War syndrome. He wears massive steel braces on his legs. And here he is trying the case by wheeling in. These days, by the way, he is a federal labor law administrative law judge. What happens when someone has vision difficulties? This is a device for people, particularly with macular degeneration. This judge had macular degeneration. He could hardly see at all. He could see out of the corners of his eyes. He's wearing headphones. Why? Because if you handed a document up, the device would scan and read it to him. Or what about what else was happening? This is one of our student fellows. He is describing to the judge everything that was said, everything that was going on in the courtroom the judge could not personally observe. And we are also recording this as part of our court record in case of appellate matters. The judge is hearing this in the judge's headphones. By the way, in the US, we've had a number of blind judges sit. I understand for a number of the federal judges, the judges' law clerks would sit next to them and whisper into their ears. This is a far better solution. How do we keep a judge on the bench if there's a vision issue happening? How do we take a talented judge without hearing, limited seeing, blind? How do we give them the tools they may want and need? This witness could not speak for real and could not hear. He's using American Sign Language, and we're doing a remote American Sign Language interpreter who is giving us a spoken version of what he's doing here. This witness was in a wheelchair, retired Navy officer. You see our judge with the headphones aiming the little video camera so he might see a little bit out of the corners of his eyes. This witness was blind since birth. Here she's using a heat-sensitive paper where we have printed out a diagram. And she's reading it with her fingers as if it were Braille. But in the real world, she normally, I don't have the picture right here, has her computer send all this information to the display and it reads it to her. Now, my court reporter, before she retired, would quit, or mutiny as she would put it, if I spoke faster than 250 words a minute, and I'm a New Yorker, so I can do it. This woman can hear at 700 words a minute, which, and this was how it used to sound like to me. Eek. Now, you might want to know that she became a lawyer. And we have lawyers and judges and numerous people in the legal professions who are blind, who are deaf, who have other concerns that might limit them in the way others might think. And this woman had macular degeneration, so we gave her a special piece of equipment. And when we realized that our jury box at the time wasn't built for this, we redesigned the entire courtroom and remodeled it. So, how far can you go? This is from Israel. And this is an individual who could not communicate. Turned out Israel had a problem with a number of people being victims of sexual assault. he would choose the letter by hitting the big red button with his forehead. That's not usual for a high-tech courtroom. But if we're worried about human rights, if we're worried about justice, that's another matter. And we even have wearables in modern technology today. So an interpretation, and then I'll end up in about 3 minutes. This was our colleagues, our founding state court affiliate. I might add that we have affiliated courts in the US, state, federal, Native American, and in Canada. And if you're from a court, consider yourself invited to join us. This was their chief interpreter, handling remote interpretation in Orlando, Florida, from a courthouse of about 40 different courtrooms. Here are some of those courtrooms. And here is a second courthouse, part of the same court. This too is part of what we deal with. So ladies and gentlemen, I have now made it to about 10 minutes to 6, which I am told is the end of this. So let me simply ask, what questions may I answer for you? I'm sorry I've been fairly quick. I certainly haven't dived too deeply into the human rights questions. I hope I have at least raised some of them. I could certainly do so with more specificity if you'd like. But I would suggest to you simply this. We are united in both countries in our search for justice, which requires fundamental fairness, accuracy, and access. And the question of how best we do that should be a matter of concern for all of us. Technology-augmented courtrooms do not exist for their own sake. It is their purpose to make justice better, faster, more efficient, and cheaper, or at least as much of that as we might manage to do. What may I answer?
Thank you so much, Professor Lederer, for that extremely insightful presentation. The people in the audience now understand why I hold you in such high esteem. So we already have a question, or rather, no, I'm sorry, it's simply for those who have to leave before the end of the question period. The key word is courtroom to get your hours for the bar. So we're open to questions. You can either write them in the discussion or raise your hand. And while you are thinking of these, I just wanted to come back on certain of the points that you made. I think you started off by talking about appropriate technology, and I believe that's really appropriate is the key word. Very often, and I'm sure you've had the same experience, and when we're discussing with courts or public bodies, and I do agree that it's not only courts, it's actually mostly agencies or professional orders or smaller venues, if you will, that will use these types of technologies, at least for now. One question that I'm often asked is, well, what is the best technology that we can buy for this? And my answer is always, well, that shouldn't be your question, because technology X might be the best technology out there, but if nobody can use it, if the people who appear in front of your court are not inclined to use that type of technology, then it might be the best, but it's not necessarily appropriate. So, for example, if you ask me what the best tablet is, I wouldn't say it's the iPad. But if you ask me which tablet I suggest to use, I would say the iPad, because most users are more familiar with the iPad, and it's a lot easier to use than some of the more sophisticated tools that are out there. So I think definitely the concept of appropriateness is the right one. As for your 3 criteria, making it more accurate, more efficient, and cheaper, definitely reaching all 3 is quite difficult. And I would say cheaper is probably the hardest one, because yes, we can make it cheaper for the parties or some of the stakeholders. But as you've demonstrated, there's a lot of technology there, and therefore there are a lot of things that you need to buy and need to replace as well. If you look at your courtroom 10 years ago as compared to now, and it's the same thing for ours here in Montreal, we've changed a lot of the technology over the years. And so that's there's a lot of money there that's being invested. I just wanted to point out the irony that while you were talking about the infrastructure, the Wi-Fi at the University of Montreal actually dropped. So thankfully, because you were also a host, it switched hosting capacities onto you, so the public did not notice that there was a drop. But I can tell you that Sylvain, our coordinator, who organized all the technology for this meeting, was very annoyed by the situation, a little stressed for a few minutes. Otherwise, for those who were interested in your explanation about the metaverse, I would remind people who are listening that David Tate, a colleague with whom we've both worked with, who's working out of Australia, has a project using the metaverse, and in fact was actually part of this lecture series. And so if you're interested in that, you can go back and listen to David's presentation. There's a comment from Lena, who says, as a litigator for over 30 years, I truly feel not examining and cross-examining witnesses in public is unfair. Many cases are won on demeanor interpretation. How do we ensure this will be protected going forward?
Now, when you say in person, I'm assuming you mean that this doesn't work remotely. And all I can do is report. I did a program a fair number of years ago, and I wish I had written down some of the details. I had a federal district judge from, I believe it was Florida, and she had tried a case with a remote witness from, I believe, the country of Colombia. And she reported the defense had called the witness, and then it was time for cross-examination. And in her language, the prosecution demolished the witness, even though it was done remotely. So I think, although many of us have concerns about whether this will work, that in fact, it is quite possible to do a highly effective job. The key question is inherent, I think, in your question, which is the degree to which demeanor evidence is, one, real, two, required or fundamental to our legal system, and three, the degree to which there's a problem with determining it remotely. We obviously don't have that much experience as yet, but I can tell you that our holographic testimony is extraordinarily realistic in the sense of the same as being there. I don't know how we prove this, except we do a fair amount of fundamental experimental work, but it seems to me that if we had a remote holographic witness, as we will have, that it's going to be exactly the same as being there. Can I prove it? Not yet.
And I would add, there is a lot of data. There has been a lot of research done out of the UK, out of Australia as well, regarding demeanor evidence. And it corresponds to what Professor Lederer mentioned, and that is that we are surprisingly bad at reading demeanor evidence, or rather, we are a lot worse than we believe that we are. And that in itself creates a whole different issue. Now, I don't know that technology exacerbates or diminishes the issue, but we also have to understand that we are a lot more limited collectively in reading demeanor evidence than we actually believe that we are.
I'm not sure we have another question, but if we don't, let me expand on that. I don't want to waste your time, but let me tell you of the incident that personally convinced me that demeanor evidence didn't work. I was teaching trial practice at William & Mary Law School. We were trying a student trial. I was the trial judge. And a witness was testifying, and I was trying very hard to determine if the witness was telling the truth or not. At which point, as I explain it, the first light bulb went off in my head. And the light bulb said as follows: idiot, this is not a real case. This is not a real witness. Not only that, you wrote the case and you cast the witness. And you're trying to determine truth. What's wrong with you? I could have lived with that. It was the second light bulb that did me in. because at the very same time, I was a real trial judge, a very unimportant one, but nonetheless. And the second light bulb said, can you tell the difference between what you're doing in this fake trial and what you do in a real case where you're trying to determine whether your witness is telling the truth? And my answer was no. And so I became a disbeliever.
I'm not seeing any other questions, and it is almost 6 o'clock. So I will simply take the few remaining minutes to thank Professor Lederer on your behalf for his presentation. Amazing presentation, to quote Mr. Thibault-Ménard. And remind all of you, again, the key word is courtroom for your bar hours. And I invite you to join us for the next session of these evenings of justice. The next one will be on the 23rd of this month, so on the 23rd of March. It will be in French. It will be with my colleague Annick Provencher, who's a professor here at the University of Montreal, and it will deal with the Canadian income, la Cour canadienne de l'impôt, so the Canadian tax court. So thank you, everyone, once again for your presence, for your participation, and thank you, Professor Lederer, for your excellent presentation. And I'm quoting here right now many people who are typing. So
thank you all for joining. I thank you for the kind words, and I most of all thank my much appreciated colleague, Professor Vermeis.
So good night, everyone, and hopefully we'll see you again soon.